The seemingly tranquil Himalayan kingdom of Nepal was gripped by a series of pro-democracy protests that came to a head in the 1990s. These sentiments brewed under the feudal rule of the 300-year-old Shah monarchy that had routinely scrapped representative institutions since the 1950s. In such a climate, the grievances of the marginalized Nepalese were co-opted and represented in a civil war by the Communist Party of Nepal, Maoist, or CPNM for short, which engaged in violent conflict with the Royal Nepalese Army and police forces starting in 1996. Nearly 10 years and 17,000 deaths and disappearances later came the victory of the CPNM, which then sat down with King Gyanendra Shah and a loose coalition of 7 Nepalese political entities to sign the Comprehensive Peace Accords. The CPA enumerated the institutions necessary to establish within this transitional context, as well as those foreign actors which would maintain the cessation of hostilities between the Maoists and monarchical forces. More importantly, though, the CPA relinquished the king of all of his political rights and reduced him to a regular citizen, turning Nepal into a democratic republic after the first Constituent Assembly elections in 2008. Even though it was signed in November of 2006, the first of the CPA's recommended bodies, the Commission on Investigation on Enforced Disappeared Persons, CIEDP, was formed in February 2015 after a long political stalemate brought about by the CPNM's inclusion of provisions for amnesty to perpetrators of gross human rights violations. Described as an independent, impartial, accountable, and high-level commission, the CIEDP, in a nutshell, processes complaints from the families of those disappeared during the armed conflict and provides compensation or relief through free education, free healthcare, vocational training, access to loans without interest, shelter, employment, among other measures deemed appropriate by the Commission. The second institution to come to fruition was the Truth and Reconciliation Commission of Nepal at the same time as the CIEDP. Its objectives, as listed on the government website, are comparable to any other TRC, but are functionalized through the, quote, investigation of incidents of gross violations of human rights and the publication of truth, identification of victims and perpetrators of the conflict, attempts to bring about reconciliation between the victims and perpetrators with their informed consent, recommendation on reparation and/or compensation to be provided to the victims and their families, recommendation for legal sanction against perpetrators to whom amnesty is not granted and in cases where reconciliation is not reached, and the provision of identity cards to the victims and mandatory post-investigation debrief, end quote. The act that facilitated the establishment of the TRC and CIEDP also formed a special court, although the court's functions and its relationship with other TJ mechanisms are unclear. Specifically, an area of concern is whether or not any case must first be heard by the two commissions before referral to said court. Transitional justice with transformative elements. Given the limited scope of the Nepalese TJ process, I questioned how this particular case study fit in with the week's theme of transformative justice, but the inclusion of the Nepalese case illustrates well the work-in-progress nature of both the nation's TJ process and the transformative approach. It is undoubted that the civil war conducted by the CPNM created the foundation for the establishment of a democratic republic in Nepal. It also created political consciousness amongst the people at a grassroots level and to some extent awareness of the need for a national socio-economic transformation. This sharp change in political culture was a dramatic transformation from the strict hierarchical caste and ethnicity-based politics of the early 20th and 19th centuries in Nepal. Correspondingly, the cessation of hostilities and the maintenance of this negative peace have been seen as reasons to qualify the TJ process as being completed. Surely the inclusion of Maoist socio-economic rhetoric in the policies formative of Nepal's TJ instruments have aided this perception of a transformative justice in the Himalayan Valley. But since the 2015 operation of Nepal's TRC and CIEDP, the commissions have seen their 2-year mandates extended 4 times by 1 year each time, and by the end of their third tenure in 2019, they were still in the preliminary phase of their work, with the Human Rights Watch report on the issue citing the Nepalese TRC as having completed preliminary investigations in less than 10% of the complaints submitted to it, and the CIDP as having started preliminary investigation in only 75% of complaints made to it. At that time, neither institution had provided a resolution or any form of settlement to the more than 60,000 victims who had lodged complaints. Additionally, the absence and unincorporation of independent civil society actors that recommended the formation of more than just one TRC at the time of the 2006 CPA all culminated in an incomplete TJ process and Nepal foregoing what Greedy and Robin describe as a truly participatory, victim-centric, positive peace-inducing, transformative justice.